Hello, my name is Susan Spancers, and welcome to my audio interview. People work with me because I show them how to create and protect their net worth through estate planning according to their goals, wishes, and dreams. What this means is I focus on what matters most to you and your family. In other words, I work for you. I can show you how to build an estate plan around solving your greatest challenges. The benefit you will receive is a peace of mind knowing that you have taken care of your family. I started my business in 1989, and my office is located in Centennial, and currently I have clients ranging from Pueblo, Colorado Springs, the entire Denver metro area, and north to Greeley and Fort Collins, so it's quite a range. I would like to thank you for taking the time to listen to this audio program today. I know that if you are listening, this has to be a very important topic of concern for you. Today, we're going to cover a very important subject, estate planning in the state of Colorado. In just a moment, I am going to introduce to you an attorney I work with in estate planning, and during this audio program, we're going to break our discussion into 3 important sections. This is going to be a very valuable program because what we are going to discuss is exactly the kind of conversation you should have with an estate planning professional the first time you meet. We'll help you get a head start on understanding how all this estate planning stuff works so you can begin the process of putting a plan in place that protects your money and your family. Estate planning can be a little confusing, and I believe the reason why so many people procrastinate is because they don't know the questions to ask, they don't know what the documents mean, they have received conflicting information, they don't know whom to trust to help them, and the perceived cost scares them away. Today, we'll address all those concerns because we want you to understand what having a revocable living trust means. So that you'll understand how this program will go, let me explain what we'll be discussing so that you will stick with us throughout the entire program. In our first section, we're going to discuss exactly what estate planning means in the state of Colorado and how the documents are designed to protect you and your family. Because of the length of time I have been working in estate planning and the number of clients I have discussed this topic with, I think I have a pretty good grasp of knowing exactly what your questions may be. But to be thorough, we did a very extensive online survey where we asked 2,500 people what their concerns were around estate planning, and we developed a research report that helped us build the content for this program. So we'll be using that information to outline the most important questions that we believe you have about estate planning, and during the first section, we're going to explain the difference between wills, living wills, powers of attorney, and living trusts. In the second section, we'll explain how living trusts work and why you may want to consider this as your estate planning choice. I know from talking to my clients that there is a lot of confusion about living trusts. Many years ago, I was confused about this topic because I received such conflicting information. I would attend a seminar and hear one piece of information, and when I discussed that information with an attorney, I discovered a complete opposite opinion. I have 5 designations, and most of them are for the specific purpose of learning everything I could about estate planning. Because of all the conflicting information I received, I knew there had to be a way to find out the facts and learn the truth about estate planning. So that is when I started my estate planning education process. And here is one of my conclusions. First, I don't believe everyone needs a living trust, but far too many people are persuaded not to establish one when I think they should have one, and vice versa. In Section 2 of this audio program, we are going to explain what a living trust is, how it's different from a will, how it avoids probate, how to transfer assets into a living trust, why it can help reduce conflict with your children, and more importantly, how it can save you a lot of money by not paying unnecessary legal bills. Let me tell you about my family. I am married. I have an adult daughter and 3 grandchildren. Early on, I decided I would much rather leave my assets to my family rather than taxes to the government or in fees to an attorney. I didn't want them to be an extra beneficiary of my estate, and I doubt you do either. So we're going to talk about how a living trust may be a great option for you. Then, in Section 3, we're going to talk about what our survey discovered as a top concern of the 2,500 people we surveyed, and that is, how do you find the right professional to work with in our wonderful state of Colorado? Not everyone who claims to know estate planning is qualified to write your estate plan. In this section, we'll outline how to find the right help and what questions you should ask. This audio program will be like meeting with an estate planning professional without leaving the comfort or privacy of your own home. After we answer all of these questions, you will have received approximately 1 hour or about $300 in a free estate planning information. We have a very packed program, so make sure you listen all the way through to the end, which will take approximately an hour. If you have to interrupt your listening experience for any reason, please note the time you pause, and when you have time to listen again, you can pick up where you left off. Now, before I introduce the estate planning attorney I work with, I think it's important to give you a brief background about myself and explain why I'm qualified to host this program today. I opened my business in 1989 and have earned 5 designations, 3 of which are directly related to estate planning. I specialize and focus in estate planning and work closely with attorneys to make sure you are receiving the documents and service that most closely match what you hope to achieve in doing your estate plan. I have attended numerous advanced estate planning classes and seminars to stay abreast of the law and regulation changes. People work with me because I can explain and resolve challenging estate planning issues, such as how does a trust work for a single person, a married couple, or for domestic couples. In addition, we provide trusts for non-citizen residents. In other words, people with green cards. What this means is that I can educate you about the best options available to protect your estate from probate, and this allows you to focus on what matters most to you and your family situation. The benefit you will receive is peace of mind, knowing your family and loved ones will be taken care of and your assets will be protected. Okay, at this time, I would like to introduce the attorney who has so graciously agreed to assist me with this interview and to provide you with some very valuable information about estate planning. At this time, I would like to introduce the attorney who has so graciously agreed to assist me with this interview and to provide you with some very valuable information about estate planning. Please help me welcome Joan Goldsmith.
Thank you very much, Susan, for the opportunity to speak with you tonight on this really important topic.
Well, we're getting to that time of year where I wasn't sure if I'd have to get you off the ski slope or off the golf course to conduct this interview. And when you think about it, in Colorado, you can do both sports all year round, except for a few months over the summer when it's pretty hard to find enough snow to ski down.
Well, you picked a good time of the year. We're right between those sports, and this topic is too important to delay any further.
Well, I agree. Joan and I have worked together on estate plans for about 10 years now, and I would like Joan to take a couple of minutes to introduce and tell you a little bit more about herself.
As Susan stated, my name is Joan Goldsmith. I'm from the Midwest, so I'm happy to be in Colorado. I graduated from Vanderbilt Law School in 1978, and I've been an attorney for 33 years, and of those, half, or about 16 years, has been spent specializing in estate planning. I've created hundreds of estate plans. I really did not keep count, but over those years, I've worked with many different people, couples, young, middle-aged, older, single, widowed, with children, without, and that was a real pleasure for me to work with, and I continue to want to do that kind of work.
Thank you, Joan. Now, getting back to our audio program, Joan and I are excited to talk to you about this subject today because we are very passionate about what we do. We love helping people with their estate planning needs because far too many people procrastinate or are never able to get straight information or enough information to proceed and end up dying without any plan. A recent survey reported that almost 70% of Americans die without a will, and that can be devastating to a family. And while having a will help and may be suitable for your situation, a consultation with a professional estate planner to determine if a more comprehensive revocable living trust may be more appropriate. Without a properly developed estate plan, your family could get stuck in an expensive and long-lasting probate process. They may fight unnecessarily among themselves because nothing is spelled out. They may pay unnecessary taxes to the government, and they may pay a lot of money to an attorney to figure it all out. I've seen this and heard this story time and time again. And let me share a quick story with you that really has stuck with me. My aunt died of breast cancer when she was 40, leaving behind 4 children in 9th grade and younger. Needless to say, this devastated our family. Left in place. He did make his wife joint tenant on his home. As a result of his death, all of my uncle's personal property passed to his wife. She held an auction to sell what she didn't want, and my cousins had to attend the auction to purchase the items that they wanted to keep. At this time, she also created a will and made her children from a previous marriage the beneficiary of the remaining property and excluded my 4 cousins. A short time later, the wife from this remarriage passed away. One of my cousins wanted to purchase the free and clear home, and which he did, and the proceeds from that sale went to their stepmother's children. Now, most people spend their lifetime working hard to create a decent and respectable net worth, and then give little thought to how, upon their death, their assets will be transferred to their heirs. My aunt and uncle were no different than how most people handle their assets. However, with the increase of blended families, surviving spouses are free to name whomever they want for beneficiaries. And remarriage is one of the primary reasons why couples consider doing a revocable living trust. I don't want you to experience anything like what happened to my uncle and my cousin. That is why I have developed this program, because I feel very strongly about educating people in Colorado. I feel that if you know the facts, you'll be able to make better decisions. Hey, Joan, let's move along, but I have a question to ask. What's the difference between tax evasion and tax avoidance?
I could guess, but I don't know.
About 20 years.
Good one.
Yeah, exactly. Okay, let's move into Section 1, the basics of estate planning. What I would like you to answer are these 3 questions, Joan. Why do you think estate planning is important to think about and to do something about? What does estate planning mean as an attorney to you? And what types of goals should we have with our estate plan?
Well, those are 3 very important questions, Susan. Estate planning has to be thought about because, unfortunately, death is not an option. And what I have run into is just what you've been alluding to, is that people naturally avoid the topic. It's not anything anybody really wants to consider. But if you don't think about it, the default that result can be much worse than if you had taken action. If you don't put your wishes down in a legal document at a time when you can think clearly, the state will take it upon themselves to decide how your assets go. Your goals may very well not be met, in addition to the delay and the expense that goes through that process. The best time to enter into the estate planning process is when there's not an immediate crisis going on, someone on their deathbed, someone just having had a stroke. That delay, that avoidance, it doesn't serve the purpose very well. So it has to be dealt with as an inevitable part of life. Estate planning, to me, it means just what I referred to is getting your affairs in order while you're of right mind, and to consider the 2 events that nobody wants to consider, which are death and disability. And the disability portion is actually equally important to the death portion in terms of how things are going to go if you cannot manage your affairs. And most of the statistics are that most people will have a period of disability before their death. So that's where the powers of attorney come in.
I happen to think that disabilities many times cause more problems than a death.
They absolutely do, and they're often not prepared for. And people who should not be having access to money or decisions about the person end up front and center and grieved, alive and well.
And things can go wrong.
That's true. They often do. In terms of the goals that we should have with estate plans, this is extremely an individual thing. Some people care, number 1, about avoiding taxes. Most people overwhelmingly want to take care of their families, want to avoid conflict among their heirs, want things to be transitionally easy. They want to set things up ahead of time so that their heirs don't have to worry about legal matters at a time of emotional grief. So taking care of the family, saving taxes, setting up, also very important, anybody with minor children to pick the guardians for those children, because again, if people don't pick their own guardians, the court will have to do it. I don't think anybody really wants that, with the delay, the expense, and the fact that they could end up with somebody that the parents never would have wanted. So the goals are as individual as the people, and we tailor the estate plan around those goals.
One thing in creating a trust is to make sure your living trust document is easy to understand for your children so that they can understand it. So when you are in the process of planning for your estate plan and are preparing the input into the documents that you're going to use, ask to see a sample document and review how it is organized and created. I really like the ones that you use, Joan, because they're organized very clearly. And if you cannot understand your own trust, your children will not be able to either. And ask for an explanation from your estate planning professional how the document is organized, and scan through the sections to see if it appears logical. So I think it's real important to see this in advance so you know what you're getting.
Absolutely. I think most people are intimidated by any legal documents, and it's not always entertaining to read, but the most important portions of the trust should be understandable to the person who creates it, to make sure that they see their wishes clearly implemented. The trusts are also easy to update. Time changes, people's life situations. People disinherit a child, they change their mind, they want to put them back. The spouse dies, people remarry, they change their location, their residence, who they want their property to go to. So if you need to change successor trustee because someone is getting too old or they decide that they're not suitable, if you want to change beneficiaries, other designees, or the property disposition, this can be done with a simple amendment to the original trust. You'll always keep the original trust date when you update the terms of your trust. So it's very important to remember it's revocable, meaning you're still in control.
And there's actually a section in your trust, Joan, where you can file these amendments so that anyone who picks up your trust will see that section and they'll know that there has been some amendments made.
That's absolutely right, assuming that people file them in that section. And they do have to take charge of that job. But it's amendable as long as the person who makes the trust is alive, and it's read, those amendments are read in conjunction with the original trust. It's an alive document. And trusts also, one major asset that they have is that if you have real estate in a state other than Colorado, and many people do with a second home, condo, you can administer that property through the trust without any extra charge after the people's death and avoid what's called ancillary probate in that foreign, we call it a foreign state. And if you had to probate in another state, you have to pay those fees. Find a lawyer in that state, which people are, often not familiar with it, a trustworthy lawyer, and that's based upon the full probate value of your total estate. So you can avoid that by setting up a trust, and very important, funding it with the real estate, with all the assets, except the ones that we're going to exclude. We'll talk about that. But very important after you establish a trust to fund it, to put the property into it. And with real estate, that involves a deed process. And once it's done, it's in.
We've actually done that for timeshares several times because timeshare ownership is very prevalent. And we've done that with several of the trusts that we've done together.
That's right.
Some of them have not necessarily been easy to do either, but we've been real persistent. Hawaii has been very difficult.
Right, but that's part of the service we provide. We're not going to rest till everything's in there that should be.
That's correct.
Another feature of the trust that we do is to reduce or eliminate altogether federal estate taxes. With these documents, we can protect up to $10 million if you're lucky enough to have that much. At the present time, Colorado does not have an inheritance tax. We don't know if that's going to stay that way, but the trust is very useful in saving a large amount of state taxes.
I believe, I think you will too, the quickest and easiest way to pass assets to a spouse, children, grandchildren is if you do have a trust. If you have a will, your beneficiaries will receive your assets minus the probate fees and the time it takes to process probate. If you have a revocable living trust, essentially the assets can pass as quickly as everything can get processed. For example, if my aunt and uncle would have had a trust, the remarriage would not have created a situation where my cousins were removed as beneficiaries.
Another feature of the living trust angle is that it minimizes legal bills. The biggest legal bill involved is the upfront charge of establishing the document, which the way we do it, it includes the funding of the property into the trust. Trust being basically an empty bucket which needs filling, which is what we do. But the settling of the trust, which occurs after death, takes maybe a few hours, but it's relatively inexpensive, much less expensive than a probate process, which, as Susan stated, it can be lengthy depending on what issues come up. If there are disputes about bills, if there are disputes about the validity of a will, disputes about who were the decedent's children legally, all kinds of reasons, failure to sell the assets so people can receive their inheritance, the estate remains open until there's a final distribution, and that can go on extensively. So in the long run, the revocable living trust will save money in a great number of situations.
Let's move along and talk about the basic documents that we provide in our trust and which most people will want to consider. And if you can just give a brief definition of what a will is, a living will, the durable power of attorney, find the health care power of attorney, the guardianship, conservatorship, and the living trust. I know a lot of people will be listening just to hear exactly what these documents are.
That's great, because I have a lot of people who come in and ask for a living will when what they really meant to say was a will. But just a basic last will and testament is the estate planning document with which probably the majority of the people are familiar. Just a document with or without formalities. In Colorado, people can write their own handwritten document that sets out who their heirs are. It can say something as simple as all my property goes to my son. So that's just the very basic estate document for outlining just what you have and who is to receive it after your death. It should appoint your executor, which we call a personal representative in Colorado. That saves time if there's an appointment of that person to handle your estate affairs. Also addressing an issue of whether bond is required for that person because they're handling money. So if bond is not waived, it can be very costly to have a fiduciary bond required. A living will is involved in situations where you have a terminal condition from which you're not expected to recover, and our language is for a period of 7 days or more. It allows you to state that you don't want heroic measures, you don't want artificial nourishment or treatment, which typically is respirators, feeding tubes, other feeding devices, and it allows you to specifically state how long you would want the feeding tube or PICU to be involved, if at all. So it, again, while you're competent and nothing's going to happen, you can state, if I were in a terminal condition with no hope of recovery, and 2 doctors have to sign off on that I don't want to be kept alive in that state. Artificial nourishment be withheld or withdrawn, artificial measures. And the greatest, I think, impact of the living will is to take a burden off of guilt, off of your relatives who would otherwise have to make that decision. A durable power of attorney is the tool that allows for management of your assets, payment of your bills in case you're disabled. And that's pretty important when you think about it. If you couldn't pay your bills, file your taxes, who would? So it's very important to set that up, again, with you having the power to designate the person you trust to handle that job, because again they have access to your money, and to put in some number of successor agents to handle that. And again, these powers of attorney are exceedingly important because of the number of times that disability does occur, or some period of incompetency. It can be temporary, it can be long-term. A healthcare power of attorney does the same thing, only for healthcare decisions when you cannot make them for yourself. You appoint somebody to make those decisions. And it's actually in many ways broader than the living will, because you don't have to be terminal for this to come into play. You just have to be unable to make your health care decisions. You could just be undergoing surgery, but not be terminal, and it's still very useful to appoint one person, usually one person, and some successors after that person, because otherwise the doctors or the hospital, wherever you are, they're in the position of having to figure out who all your kids are all around the world and contact them and try to get a majority consensus. So that obviously is cumbersome and very avoidable. Guardianship is a court proceeding through the probate court for the appointment of someone to handle the management of the person who is incapacitated, needs protection for whatever reason, health, alcoholism, incompetency of any kind. So you appoint a legal guardian. Obviously involves, people are familiar with guardianships for minor children, but this is referring to guardianships for adults who are incompetent, incapacitated. And conservatorship is an aligned process that involves management of that disabled person's assets. So guardianship, conservatorship often go hand in hand. Documents that we do allow the people to designate their own preferred guardian or conservator, whereas if it's not done, the court again is in the position of selecting someone, and that can be a long process. There can be nobody suitable that the court can find, whereas you might have had a friend that you trusted in that role. And the living trust is what we've been alluding to, a document that is created during your lifetime, into which you transfer your assets during your lifetime, and it allows for management of those assets in case one of the trustors who creates it is incapacitated. It allows for the tax planning benefits that we've referred to, for holding back money from children until they're of an age that you think is appropriate for them. It doesn't have to be 21. Most of ours are not. It's held further than that. It's divided into different allocations so they don't get their money all at once. So the trust takes care of the tax aspects, the disposition aspects, the protection, the beneficiary aspects, and who's going to stay in charge after someone is incapacitated. So there's some overlap with the power of attorney, but if you have the living trust with a designated successor trustee, that will be a broader document. So those are the basic estate planning documents. That's covering the gamut.
That's great, Joan. As you were explaining, it just comes to mind what a terrible position people who do not do some of these documents leave their families in, trying to guess what their medical wishes would have been, that type of thing. It's a very difficult process, if you will.
That's absolutely true. And I have seen people who will pick one child. One child might be good with money and the other, but they're too sentimental and they really don't want to be kept alive artificially. So they pick the very practical child to do the health care power of attorney. But the great thing is that allowing the people we work with to choose exactly who they want in those roles, which are, they may not happen, but if they do, you want to fill that role yourself.
Yeah, exactly. And most of the people that I talk to, they don't want to be a burden, and they want to help with the decision-making process.
I hear all the time, I had people prepay funerals, they put everything in order, where it's such a gift to their children to be able to walk into that and have all the business aspects taken care of.
Yes, it is. It is a tremendous peace of mind for the person and their families when those types of decisions are made. I'd like to talk about the 3 basic options that people have about estate planning. And those options are doing nothing, and as we discussed earlier, about 70% of the population in the United States do not have a will, so I guess that means about 70% of the people out there have chosen to do nothing. The other option is to create a will, which at least gives some direction. I believe with most wills, the power of attorney for health care, and then, of course, the purpose of our interview tonight and our audio presentation is to offer more explanation as far as what a living trust is and what it will do. So those are the 3 options: doing nothing, using a will, or using a trust. Now that we've outlined what all the documents mean, let's discuss the living trust in detail. Living trusts are quite popular as far as estate planning and the documents that are needed, but let's clear up some of the confusion about them. We're now in Section 2 of our audio presentation, and Joan is going to explain how a living trust works, starting with how a living trust is different from a will.
Well, a living trust involves the transference of the property of the person making it into that trust, into that bucket, while they're still alive. It doesn't wait till after they're dead, and it allows for a management structure of the person's assets during their lifetime, covering the situation where they are older or infirm or incapacitated, and they cannot or do not even want to manage their own assets anymore. There's always a successor trustee built into the trust. Whether the trustors and the other beneficiaries are going to get principal or income during life after death, it sets out a mechanism for covering how your children are going to get through college. How's that going to get paid for? When will they get their first allocation of money? Do you want them living lavishly? Do you want them having to work? All of your values can be built into the terms of the trust in the way that money is distributed. Money is a very powerful tool, I have found, and affects motivation, affects scholarly endeavors. So a revocable living trust is created and funded during lifetime, and it can last for many, many years. The will just comes in and sweeps up what's left after someone dies and says where it will go, who will get it, and almost always involves a probate situation.
What do you think the pros and cons are to a will?
Well, for some people, a will, as you've pointed out, can be sufficient or comparable. If people don't have minor children, if they don't have many assets, in either one you can favor or disfavor heirs. But that's one reason that it's important to do something, because the state of Colorado will protect your heirs and make sure that they get your assets, and that may very well not be what you wanted or not in the proportion that you wanted. A con to a will is that it can be challenged relatively easily, and it takes time. The first thing that comes up when someone dies is, how am I going to pay for the funeral? How am I going to continue to live in the house and pay my bills? And it takes time to get all that into place, whereas the trust works seamlessly to get the funds to the survivor. The will is less expensive up front. One downside is that it is more public, and most of the time, as long as there are any assets of certain sorts, it does have to go through probate, and it would require a trust in any case, called a testamentary trust, a trust created within the will, to control the funds for the minor children and the distribution. So it's going to end up in a trust situation on top of the will situation.
I have an experience with people immediately after a death. They were shocked when they went to the funeral home and funds were demanded. The funeral home would not proceed without payment in hand. And these people they were distraught because they didn't have funds readily available, as most people don't, and they didn't know where the funds were going to come from. And they had to survey extended family to come up with enough money, and so it was a very distressing time for these particular people. You just hear so many things when you work with people in these situations, and so it's pretty important.
That's right, and that is not at all unusual. Often a funeral home will want an assignment of any life insurance proceeds. They want somebody, it can be the executor, the personal representative of the will, to sign on the bottom line that they are responsible for those costs. So, yeah, I find that when there's not cash available readily, and obviously that time is very much of the essence in that situation, it is a situation where they end up passing the hat and hoping they get their money back from the estate. Just another layer of stress that is avoidable.
Right, and it's actually embarrassing that at that time in that situation, when they're in their grief, they have to deal with something like this. What happens if you don't have a will
Well, if you don't have a will, the state of Colorado will decide, depending on how your assets are held, they will decide who will benefit from your estate, and it's a multi-layered structure of if you're married, if you have all the same children as your spouse, or if you and your spouse have different sets of children. If you have no children and no spouse, then it goes in a different manner, starting with going up the line to your parents if they're around, and then down to your brothers and sisters, and possibly to nieces and nephews. And the bottom line is it could end up in many places that you did not want.
Yeah, it can be pretty complex.
Right. But it's something that, people, they don't give a lot of thought to, even nowadays, ahead of time. I always used to tell people, because I worked with so many relatively young people, and I would say, well, you do it, and you put it away, and you have peace, and you know it's done, and then go out and have fun. Don't think about it.
Mm-hmm.
But do it.
Good advice. Well, I'd like to kind of summarize some of the things that you've said and perhaps throw in a couple of other thoughts about what a living trust is. It eliminates the needs for your heirs or your surviving spouse to be subjected to the unnecessary cost and the process of probate. I think we've discussed probate enough. I don't think we need to go into that, but that's what a living trust, a properly funded living trust, will do. It also provides the entity to ensure that you either pay no estate and inheritance taxes, or at least minimizes them. It can establish the means to provide for your needs in the event you become incompetent, because incompetence, when you become aged and a very senior citizen, and a living trust also provides the entity for the support and education for your minor children, because if you don't set out some direction as far as how you want your children to be taken care of, then it becomes a court decision. Oh, Joan, if people just knew what's in store if they don't actually do the planning themselves. It also creates a vehicle to indirectly care for a handicapped child without jeopardizing his or her government benefits. And I don't believe you touched on that. And that can be a huge issue if you have a disabled or handicapped child, a minor or as an adult, because there are specific things that you can do to set things up so it doesn't jeopardize if they're receiving any type of government benefit.
Well, you're absolutely right, because there are income limits for certain governmental benefits that the trust document requires and allows the assets of that person to remain in trust, except for those supplemental needs that are sanctioned for receipt of those benefits. So for people with disabled, we deal with mostly disabled adult children. That comes up more often than you can imagine.
Oh, it does. I get the question quite often, what can we do? And so there is a remedy for that situation. Living trusts also assure privacy of your financial affairs. And I know when we did our trust, my husband and I, the privacy issue was a big thing to me. I just wanted, you work hard your whole life, and you don't go around telling everyone what your assets are, what your net worth is, or what you earn, and that type of thing. And I wanted to carry that privacy, I guess, to my grave, because I wanted, yes, and beyond, and because I wanted to keep it private. And so that's the one thing that was a big deal to me when we did our trust. Well, a living trust is a legal document that actually transfers the ownership of your property from your personal name into the name of the trust. And that is what makes the living trust come alive, and that's when you actually fund it. But you're transferring your assets into the trust. Placing your assets in a revocable living trust has absolutely no effect upon your borrowing ability or your ability to get a loan. You have the same right to borrow against your assets in the trust as you did when they were outside the trust. So don't be concerned about that. That's one of a very common question that I get is, well, what if I need a loan? That type of thing. It will not change your ability to get a loan. Well, Joan, since a revocable living trust is not registered, is private, and is not monitored or approved or supervised by any federal or state body, how do we know that the trust is good, that it is legally acceptable, and whether or not it's a worthless piece of paper? How do we know that?
Well, that's where you have to be careful. I have seen trust documents for $59 in the back of Sunday magazines, and I actually ordered one just to see what it was like. And it was
Did you?
Yes, about 3 pages of not much. So you have to be careful and know who you're working with, and be assured that the trust there's more than 200 provisions, very important, that have been drafted over the years by highly competent tax professionals and legal professionals that are included in the trust that we use, you and I. If you work with someone else, it's important to ask the attorney to see the document and be wary of what we call thin trusts, the Parade magazine trusts, that only have a few pages, and the pricing is commensurate with that.
I guess you get what you pay for, don't you?
Sometimes, yes. And let the buyer beware, as always.
Well, let's talk about the importance of having a universal trust. And a universal trust is a revocable living trust that is applicable in all 50 states, because that's what we use, that's what we offer. And this is very important if you own real estate in more than one state, or if you live part-time in 2 states or more states, or if you ultimately plan to move to another state. It's important to have a universal trust so that if you do move, it's acknowledged in the state that you move to.
Right. Well, a question comes up all the time where people are going to be moving to another state, and they're wondering whatever their legal documents, whether it was a will or a trust, is still going to be honored there. And there are special provisions in our trust for certain states that have peculiarities, but it should be a one-time deal. We get you into the trust, and although you can always amend it, you won't ever have to throw it out and start over again. And that trust should serve the rest of your life in any state where you happen to live.
If there happens to be a law change, we actually receive notice of that and can inform our trust holders of the change, and amendments can be done to apply the change. I mean, this doesn't happen often, but it can happen if we need to.
That's right, and because we do have a support system for monitoring all of that, updated newsletters, and because, as you know, those things do change.
They can. Only upon death, the only person who has a right to see the trust document is the successor trustee. The name of the revocable living trust is submitted only to the IRS, and that is to get a tax ID number, and that would be upon first person's death, who is the trust holder.
That's correct.
Do you know if a revocable living trust shelters your income from income taxes?
No, unfortunately.
We wish, huh?
Yeah. The work continues.
Yes. And we don't lose any of our income tax deductions by placing assets in a trust either. That all stays the same.
That's right. It's considered your money, for tax purposes, for good and bad, for income taxes, for deduction.
Yep. And the same with the mortgage interest. If you put your home in the trust, you can still deduct it. And it's also important to put your rental property into the trust, and rental income is treated the same as before you put the trust into effect. There are no changes there. And what about Social Security benefits?
There's no effect of the living trust on your Social Security benefits because Social Security is paid to human beings.
And the other thing is, people ask me if they have to put their stocks and bonds, and the answer is yes. You place all of your assets, anything with a deed or a title, be transferred into your trust. And we show you how to do that. You're not pushed off to figure this all out on your own. We give assistance with that. And what about homeowners policy?
Well, the policy follows the asset, the home. So you don't have to change the policy to the name of the trust or notify the insurance company of the change in ownership. We do record the deed that transfers the house into the trust, but the homeowner's insurance covers the home and you as the insured.
Yeah. So there's no changes need to be made with homeowners insurance. I think it's important to stress that only a properly funded revocable living trust avoids probate.
I have found over time that it's not unusual for people to have inadvertently left out an asset from the trust. For that, there is a document that's provided with the package called a pour-over will, which places that omitted property into the trust. But then that does have to open a probate case for that. So the remainder of the trust is still good, but it does require that extra step to put that omitted property into the trust to be administered. So what we tell people when we execute these documents is that it's very important to maintain as you buy and sell property. It's a living document that has to be kept up to date. And the people do have to be aware of the extent of their assets and what the ownership of those assets is. And they're always free to call us with any questions about how to transfer that property.
Why does a living trust avoid probate, Joan?
Well, that's assuming all the property is in the trust, has been titled. It avoids probate because it has a succession section, what occurs, distributions upon the death of the first trustor and then the second trustor, and it is self-contained for how those distributions are to be made. So the transference of the titles, which is one big thing that probate does, transfers the house to the designated beneficiaries or transfers. The living trust takes care of the transference of property titles within the trust. The successor trustee has the power to transfer any property that is within the trust according to the trust terms, and it's very important that trustee is a fiduciary. They have to follow the wishes of the trustor expressly and honestly and diligently. But they have the power with a stroke of a pen to sign the deed over to the people who were designated to receive that. Whereas through probate, the personal representative has to be appointed, and then they would then have the power to execute a deed to whoever is supposed to get it.
We haven't talked about the probate process in Colorado begins with an estate worth $50,000. Okay.
Right. Under that is considered a small estate and can be handled with an affidavit. Unless there's real estate. I don't know too much real estate under $50,000, but
no.
I guess it's possible.
I suppose, but I can't imagine. How do you transfer assets into a living? Things like real estate, bank accounts, brokerage accounts, and qualified plans like IRAs and annuities. How do those things get transferred into the trust, and do we transfer all of those assets?
Well, no, we don't, but we'll get to that in a second. One of the first things I do, usually the same date of execution of the trust, is I've prepared deeds, warranty deeds I do, for Colorado real estate, which I have the people sign, which transfers from them to their trust. I use the warranty deed because I found that is essential to the continuation of title insurance, and we don't want any issues with that. So I take care of it's just another kind of deed for the real estate. The bank accounts, the brokerage accounts are transferred with a letter of instructions, and we have that letter in a form for people to use. Now, the qualified plans such as IRAs and also annuities, we don't want to transfer into the trust.
And then let's move to changing a living trust, and basically all you need is an amendment. What I'd like to do now is go back to our audio listeners because I have a question for all of them. As you have gathered this information, and hopefully Joan and I have answered most of your questions, what I'd like to do is ask, is there still one thing holding you back from completing your estate plan? And the reason I ask you this is because I frequently run into the following situation. If you are married and have minor children, here is what I commonly hear, and that is you cannot agree upon who to name as guardian for your children. And it's such a big issue, and I find that it creates a lot of conflict between couples trying to arrive at a mutually agreeable decision. So please don't get discouraged. I have a solution for this. In fact, I have a 100% batting average in overcoming this dispute between couples. which is part of my process if you decide to work with me. So if this is an issue for you, please let me know. I know how to help you, and I can help you resolve it. Let's move along to our third and final section, and at this point in time, I hope you are getting your questions answered and are getting more comfortable with this whole estate planning issue. Your next step is to hire a professional to help you design and create your very own revocable living trust. Now, almost any attorney can write a will, but a living trust is different. And I think Joan has a few thoughts about how our trusts get created.
Right. And I think I need to be clear that Susan is an excellent estate plan consultant, but she is not allowed to practice law. So an attorney has to prepare the document. If you happen to decide that Susan and I will be your estate planning team, we will assist you Susan will assist you in completing the trust workbook, which outlines all your assets and your special wishes and the schedule of distributions. And Susan is highly detailed on that, making sure to pin down everything with more and more questions. As your attorney, I will consult with you prior to preparing your trust documents, and I will prepare the trust documents themselves. And Susan will notarize the documents, get them executed, and assist you in funding the trust, and I will also part of that with the real estate transfer.
And funding your trust is so important, and too often I've seen people invest good money to write a trust where the assets were not properly funded into the trust, and that leaves you with nothing more than an expensive will. So Joan and I are very passionate and very detailed as far as following up and making sure that your trust gets funded. Now, it's important to find the right professionals to assist you with this very important plan. So let's talk about how to find the right professional help. And here are a few guidelines that we have arrived at to help you to pick the right professional. And here's a list of questions, and we'll go through these very quickly so you get an idea of when you're ready to move ahead with your estate planning. You can ask, how many years have they been performing estate planning work? And if you want to have a living trust created, ask the attorney if they specialize in creating wills and trusts, or is it a sideline that they really don't focus on? The second question you can ask is, if you have a large estate, let's say it's worth over $5 million, does this attorney have the experience with tax planning or have associates that they can assist you with more strategic planning issues with the higher net worth trust and what they would entail? The third question is to ask how many estates the attorney has settled. An estate planner who has seen his or her documents administered and settled is one who understands the entire process and can advise you on issues that may arise after your death. The fourth question you can ask is how much they charge for the preparation of your will, trust, or both. And if the professional charges by the hour, ask them what type of information they need so that you can receive a ballpark estimate, because you don't want this to become an hourly billable process. You really need and should be able to get an estimate of what the total cost will be. Joan, did you want to say something about what you charge for your documents?
Varies according to needs of the particular people, but it's in the area of $2,000 for a couple for all these documents.
Everything that we've been talking about, right?
Everything, all the ancillaries, all the help with funding.
Other than the cost to record the deeds, and that's just a nominal fee.
Very minor, yes.
And then the fifth question you'll want to ask is, how long does it take to prepare your estate planning documents? Because this can be really important if time is of the essence. And this is where Joan and I will make it really easy for you. The workbook preparation takes about an hour. The document processing time takes 3 to 4 weeks, and then it takes about 45 minutes to notarize the documents. And then to fund your trust, I typically get everything prepared, and I review it with you, and it takes 15, 20 minutes. And then you take those instructions and you go out and do. This process will vary from person to person, so we can't be real specific, but funding the trust is rather simple. It just requires some instances a little bit of legwork. And then question number 6 that you can ask your estate planning consultant is if they will offer a free consultation, and my answer to that is absolutely. Do you have a comment about that, Joan?
It would be wonderful for you to arrange a complimentary consultation with Susan if more complex issues come up during your discussions with Susan, and believe me, she will get to the bottom of those. Then I'm happy to offer my services with an additional complimentary consultation.
Well, Joan, I hope this program has been helpful for our listening audience, and I think we've given them enough information so they can get started in the right direction. And for all of you listening, I understand that you probably have additional questions at this point, and I would like to extend an invitation to give me a call. If you have any questions, you can email me or you can call me at my office at 303-766-9599, and I'd be happy to help you. And I would like to thank our expert attorney, Joan Goldsmith, for being with us.
It's my pleasure.
Joan and I have worked together to help the fine people of Colorado create solid estate plans. Again, if you'd like to see if we'd be a good match to help you protect your family and your estate, I invite you to call my office, and I'd be very happy to answer your questions. And in the end, only you know what your situation is and what you hope to accomplish regarding protecting your assets from taxes and probate. People work with me because I offer clarity to complex estate planning situations. I have a real passion, and so does Joan, for what we do to help people resolve these issues. I am very patient through the education process as I explain the many options available to my clients. And what this means is I receive a lot of satisfaction when I help my clients build an estate plan around their vision, their goals, and their dreams. I show people how to create and protect their net worth so they can leave a legacy and pass their assets along to their family. The benefit you will receive is the satisfaction knowing you have resolved many unanswered questions by putting a plan in place. What could make you happier? Again, thank you for listening to this program, and have a great day.